Okay, Mr. Giles.
Chairman, thank you. With some trepidation, Mr. Chairman, I'm going to attempt a Stimson-Ferguson maneuver here to try to save us all a little time with the company's...
We're going to name this after you, and I like it.
She deserves it, Mr. Chairman, in my opinion. With the company's approval,
hang on.
Stab at this.
What do you need? They already sworn in. They're saying once. You good? I've been confusing Miss Tackett all morning long, so I take credit. All right, Mr. Giles.
All right, subject to this working out, I have no questions for Dr. Wright, and we'll see if we can make this quick with Mr. Karen. Ms. Karen, you testified in the Duke Energy Carolinas proceeding before the commission last month, did you not?
Yes, I did.
We all have to remember now. Yes, it was last month. And you remember my colleague, Ms. Bridget Lee for Sierra Club, asking you a series of questions about the company's coal ash management practices in that case.
Yes, I do.
Recognizing that Duke Energy Progress is a different utility and that company and site-specific facts may differ, subject to those caveats, Mr. Karen, if I asked you the same questions today that Ms. Lee asked you in that other proceeding, would your answers be the same?
Yes, they would.
Thank you, Mr. Karen. And with that response, Mr. Chairman, I would request that the Commission take judicial notice of that portion of Mr. Karen's testimony that responded to the questions of Ms. Bridget Lee on behalf of Sierra Club in the Duke Energy Carolinas proceeding, docket 2018-319E. And the transcript reference I have is volume 6, pages 1249 to 1263.
We will take judicial notice. Thank you.
And that's all the questions I have. Thank you, gentlemen.
Thank you. And the Ferguson rule is intact. Okay, let's see. Mr. Elliott.
Chairman.
Sorry, you were standing there and I was just looking who was next on the list.
Well, I didn't know whether to interrupt your chain of thought. I'm sorry. Thank you, Mr. Chairman. I'm going to need the Elmo. Thank you. Mr. Karen.
Yes, sir.
How are you this morning?
Fine, thank you.
All right. As I understand it from your testimony, that during 2014, you held the position of general manager in the Ash Basin Strategic Action Team, referred to as ABSAT. Am I correct?
That is correct.
Can you tell me a little bit about what your duties were in that capacity?
My role in the ABSAT team was to responsibility for the overall governance and programmatic items that we were working on as part of the establishment of the ABSAT team.
All right. And, well, and I guess, did it have to do with remediating coal ash ponds?
Well, it was not the remediation of coal ash ponds. The ABSAT team was established to take a programmatic look at our coal ash management practices, looking at how we were going to strategically close those basins and evaluating those processes in accordance with the pending CCR rule.
All right. So would it be fair to say that as a part of your responsibilities as general manager in the ABSAT team, you had to familiarize yourself with the various coal ash ponds operated and maintained by Duke and Progress?
That is correct.
And as a result of your responsibilities and your experience, I understand your testimony to be, and I'm simply looking at your summary of a moment ago on page 2, at each, leading up to the CCR rule and the CAMA implications on coal ash pond maintenance and operation. Prior to that, at each step in the environmental regulatory evolution process, Progress has been in line with industry standards and has reasonably and prudently managed CCRs and its coal ash basins. That's your testimony, isn't it?
That is correct.
And directing your attention to the Robinson coal ash pond, if I may. It's fair to say, is it not, sir, that Progress's operation and maintenance of the Robinson coal ash pond has been in compliance with all state and federal laws prior to its remediation, correct?
That would be correct.
All right. And for instance, it would be fair to say that at least prior to the consent order in July of 2015, the Robinson coal ash pond met or exceeded the applicable regulatory requirements. That's fair to say, isn't it?
That is correct.
And so in meeting or exceeding the applicable regulatory requirements, it would be true that Progress managed its Robinson coal ash pond to maintain proper control of dust, odors, litter, vectors, and fires or open burning. That would be fair, wouldn't it?
We manage that facility and that station in compliance with the regulations.
And it would be, and in that regard, it would be fair to say that the company met or exceeded the requirements that it maintained the final 2-foot soil cover in place for the coal ash pond. That's correct, isn't it?
We have not closed that basin at the Robinson Station.
But you wouldn't, if the Department of Health and Environmental Control found that you were meeting or exceeding that requirement, you wouldn't argue with DHEC, would you, sir?
I'm not sure I understand the question. Can you clarify that for me?
Sure. You understand that in maintaining and operating the coal ash pond at Robinson, you had to maintain a 2-foot soil cover in place on that coal ash facility, correct?
We have not closed that or capped that facility yet.
So your understanding is that you didn't have to maintain the 2-foot soil cover in place until you closed the pond?
Yeah, I'm not familiar with that specific requirement on that issue.
Well, would you agree that that at all times up to July of 2015, the slopes of the pond, the top slopes and the side slopes, were maintained in a manner that met or exceeded regulatory requirements?
You're talking about the dam itself?
It's the entire structure fill area, according to the regulation. Yes, sir.
The dam was maintained at the Robinson Station in accordance with the requirements.
All right. And it would be true, would it not, sir, that the site was maintained and operated in a manner to protect groundwater and surface water quality at all times up to July of 2015. Isn't that true?
We maintained that facility in accordance with the requirements.
All right. Now, sometime prior to July of 2015, Progress employees negotiated a settlement, a consent agreement with DHEC concerning the closure of that Robinson Pond, didn't they?
The Robinson facility, yes.
All right, and I think Mike Rue was responsible in part for negotiating that consent agreement?
Yeah, I was not part of those negotiations. I know Mike Rue is a member of our regulatory team. I'm not sure if he was involved directly in that settlement.
All right. And you are aware, because you mentioned it in your testimony, that Duke Energy Progress and DHEC entered consent agreement 15-23-HW, are you not?
Yes, I am.
And as I understand your testimony, the Robinson coal ash pond, and perhaps the Lee, but the Robinson pond was not remediated subject to the CCR rule or CAMA, but was rather a specific South Carolina compliance obligation. That's your testimony, isn't it?
I think what you need to understand is there's 2 facilities at the Robinson Station. There's what we call the lay of the land area, which is about 300,000 tons of ash. And that happened prior to 1960, prior to the ash basin, the active ash basin, or the basin at that station being built. At that time, it was common practice in the industry to take the ash, this is in the 40s and 50s, from a facility and deposit them in an area around the station that was typically a depression. So we did not build a dam. It was not wet sluiced. It was ash that was staged or stored at that location. So that's the lay of the land area. And then we have the Robinson Ash Basin, which is also known as the 1960 Ash Basin, that was built late 50s, early 60s. And at that time, we started to send ash to that ash basin and ceased sending ash to the what we consider the lay of the land storage area.
Good, and thank you for that. And both those facilities met or exceeded DHEC's requirements for those facilities. Isn't that true?
We operated those facilities in accordance with the requirements.
Now, I'm going to show you a copy, my copy of Consent Agreement 15-23-HW. You may have a copy that you prefer to read from, and I've got a copy for council. Thank you. And I'd ask you, Mr. Karen, if you recognize that document.
Yes, I do.
All right. And if it suits you to work from that document, I'll put my copy on the screen. And at first, I would draw the Commission's attention to the label of the document, and you tell me if I'm reading this correctly, but it's in regards Duke Energy Progress, Inc., H.B. Robinson Steam Electric Plant, Darlington County. Have I read that correctly?
Yes, you have.
And it identifies the document as a consent agreement. Have I identified that correctly?
That is correct.
And then we have the DHEC number assigned 15-23-HW, correct?
That is correct.
And this is the consent agreement by which Progress, and I call it Progress because it's easier for me to remember Progress than DEP and DEC, but by the consent agreement by which Progress negotiated the closure of the Robinson coal ash pond, correct?
That is correct.
Now, I want to draw your attention, if I may, to page 2 of 12, please, sir. And beginning on page 2, the parties set out the findings of fact. Am I correct?
That is correct.
Now, isn't it the case that there is no finding of a violation of your permit with regard to the regulation of the Robinson coal ash pond in this consent agreement?
Yeah, I'd have to review the entire consent agreement again, but I do not believe there was a notice of violation.
And that would stand to make sense because, as you've testified, Progress was at all times in compliance with the rules and regulations by DHEC and met or exceeded all the standards, correct?
Yes, we were in compliance with the regulations at the time.
All right, so, and it would be fair to say that there was no fine levied against Progress in this consent agreement. Isn't that true?
I believe that is correct.
Now, I want to draw your attention, if I may, please, to page 10 of 12. And I'm going to draw your attention in particular to paragraph 16 first, but I'm going to try to get it perhaps where the Commission can read it. About the best I can do, gentleman, lady. And it reads, upon Duke's successful completion of the terms of this consent agreement, the company will submit to the Department in writing a written final report. The final report shall contain all necessary documentation supporting Duke Energy's remediation of the site and successful and complete compliance with the consent agreement. Once the Department has approved the final report, the Department will provide Duke Energy with a written approval of completion that provides, and I highlight, covenant not to sue Duke Energy for the response actions specifically covered in this consent agreement, approved by the Department and completed in accordance with the approved work plan reports. Do you see that language?
Under item 16, yes.
Yes, sir. All right, and so notwithstanding any other provisions of this consent agreement, including the covenant not to sue, the Department reserves the right to require Duke Energy to perform any additional work at the site or reimburse the Department for additional work if Duke Energy declines to undertake such work. And indulge me. I'll stop there. Have I read that correctly? You can read more if you'd like.
That's item 17?
Well, I meant to read just through 16.
Okay.
So 16 provides that when you complete your work here, DHEC won't sue you, right? That's what a covenant not to sue is, correct?
Yeah, I'm not an attorney, but the document speaks for itself.
Yes, sir. All right, now I want to draw your attention to paragraph 18. In consideration for the Department's covenant not to sue, Duke Energy agrees not to assert any claims or causes of action against the Department arising out of response activities undertaken at this site or to seek any other costs, damages, or attorney's fees from the Department arising out of response activities undertaken at the site except for those claims or causes of action resulting from the intentional or grossly negligent acts or omissions of the Department. However, Duke Energy reserves all available defenses not inconsistent with this consent agreement to any claims or causes of action asserted against Duke Energy arising out of response activities undertaken at the site by the Department. Have I read that correctly?
Yes, you have.
All right. And then last, Mr. Karen, I want to draw your attention to paragraph 19, if you see that. It begins, employees of the Department. Do you see that language?
Yes, I do.
Employees of the Department, their respective consultants and contractors, will not be denied access during normal business hours or at any time work under this consent agreement is being performed or during any environmental emergency or imminent threat situation as determined by the Department or as allowed by applicable law, correct?
That is correct under Statement 19.
All right, so under your consent agreement that you've negotiated, key terms are that the Department, DHEC, has agreed or covenanted not to sue you, correct? Paragraph 16, correct?
That's what the document states.
Yep. And under paragraph 18, Duke, however, retains certain defenses and an opportunity to sue DHEC for gross recklessness, correct?
That's what the document states.
And then last, the consent agreement provides that DHEC will have access to your site during the remediation, correct?
That is correct.
Good. I have no further questions, Mr. Chairman.
Thank you. Nucor. Thank you, Mr. Smith. ORS. Thank you. Commissioners, questions? Mr. Belser.
Good morning. How are y'all? Good. Mr. Karen, I was reading or following you in your summary, and in the first paragraph, do you have it?
I have it, yes.
Thank you. There's a sentence, the second sentence, Duke Energy Progress's request does not include any costs that have been incurred related to fines, penalties, or guilty pleas. So I would say, I read that to say y'all are not asking recovery of any fines or penalties. Is that a fair characterization of that statement?
That is correct.
Okay. Or any cost associated with events related to those fines, penalties, or guilty fees. Could you explain that statement to me?
On that context, that would be the cleanup of the event following Dan River, the remediation costs that were involved in the work we did with the river, on the river.
Would any cost associated with events related to those fines, penalties, or guilty pleas also include legal expenses? Legal cost?
I can't speak to the legal costs. Mr. Wright may be able to, but I
I'm
don't believe they'd be
I'm
in
trying to understand your sentence.
My understanding is they would not be in there for those cases where we pled guilty or there were violations.
Any cost.
Any cost.
The word is any cost.
That's correct. Any
Are
cost.
legal expenses cost?
Yes, they are.
Thank you. I'm not trying to play gotcha. I'm just trying to see where we are.
I understand.
Dr. Wright, how are you this morning?
Good morning.
I was looking and following along on your summary, and on page 4 at the top of your summary,
Yes, ma'am.
I believe this is discussing your responding to ORS witness Ham, and you stated one category does not relate to environmental violations at all, and the other category relates to ongoing litigation that the company is reasonably defending where there has been no finding of environmental violations. So if it's defending but there has been no finding, does that mean the case is concluded or not?
The ones that Mr. Whitliff has in his testimony, in his exhibits 5 to 5.4, those cases have been concluded. And in those cases, the state actions that are part of the litigation expenses that I understand that ORS is trying to disallow, in those state actions, the company was not found guilty and there were no violations in any of those findings. So if you were to go to Mr. Whitliff's testimony and go through those exhibits, there's some that relate to Dan River and then some that relate to other cases. And those other cases were actually brought before CAMA. They were brought by other parties. It wasn't the state that was bringing those cases. But there were settlements related to those cases, and in those settlements there was no admission of guilt or no violation cited.
In instances where a case is brought and the company has to defend itself, and I understand that they have to defend itself, but where there is either a guilty plea or a finding of violation of environmental laws, you were on the commission in North Carolina, is that correct?
Yes, ma'am.
Would y'all have allowed legal expenses associated where there was a violation?
Well, I don't recall, but I will say that in my discussions with the company, they have said that in a situation where they have been found guilty and the litigation is concluded, that that they would not seek recovery of those types of costs. But in the case that we have here, the company, they were not found guilty and there were no admissions of guilt. The other litigation matter also was related to the insurance claims. Okay. So that's the one that I'm talking about. That there's no finding of does not relate to environmental violations at all.
Okay, thank you. I appreciate that. And Mr. Karen, I do have one other thing for you. Were you involved with the consent order with DHEC that was entered with DHEC?
With regards to Robinson?
Well, just with the cleanup of the coal ponds.
Yeah,
and
I'm familiar with them. I was not directly involved in those settlement agreements.
My question is, that consent agreement came about after CAMA was passed, is it not? Did it not?
Yeah, I think that was 2015.
Okay.
We signed that.
Do you know who initiated discussions with DHEC to enter into the consent agreement?
I don't know which party started that conversation, but we were having conversations with all of our regulators in that 2014 time frame. They had questions about our operations, and we were responding to those.
Okay. Thank you very much.
And let me make sure I'm perfectly clear. on the litigation expenses. If there's an appeal, then that case is not concluded. So, you have to go to conclusion.
I agree with you on that.
Okay.
Thank you. Thank you for clarifying.
Thank you.
Thank you both.
Commissioner Hamilton.
Thank you, Mr. Chairman. Dr. Wright, this is for you, sir. On page 12 of your pre-filed direct testimony, you referred to order docket 26.
Get in front of that microphone, Commissioner. I
Okay.
can't hear you.
We'll keep trying. Maybe we'll get it right one day.
You're getting better.
All right. Thank you, sir. Let's get back to Mr. Dr. Wright. On docket 2016-227E, in this order, the commission approved the coal ash removal over a 15-year period. Now, I'm not going to question whether this was a precedent or not, but what drove the company to change from the 5-year from the 15-year we had approved to recover the cost to the 5-year?
I'm not sure what was the driver of that, because I wasn't involved in those accounting issues. But usually what you're trying to do is recover the cost as quickly as possible so that you can save money for consumers. Because if the longer you recover cost, you're having a return on those costs. And so if you recover them quicker, usually you can actually wind up saving a little bit of money.
You can save it over the short term, but the long term, the ratepayers would not be paying as much.
Well, the ratepayers actually may wind up paying more if you have a lot of carrying cost.
So there are two sides to the issue.
Yes, sir.
And we're not going to question the precedent. Mr. Kevin, you might have more information on this, sir.
No, I'm sorry, I do not.
Okay. Thank you both for being here.
Thank you. Commissioner Williams.
Thank you, Mr. Chairman. Gentlemen, just a few questions. First, Dr. Wright, what facts or other evidence supports your belief that the North Carolina legislature would have adopted coal ash regulations similar to CAMA after the CCR rule was finalized, absent the Dan River leak?
I discussed this a little bit in my direct testimony. After the CCR was adopted, the federal CCR, it encouraged the states to look at these issues and adopt not only the CCR but policies specific to the state. Now, if you look at what has happened around the Southeast, in Virginia, they just recently adopted legislation. And they had actually adopted the federal CCR, but the legislation they adopted went beyond the federal CCR and required excavation of all the Chesapeake Bay area coal-fired facilities, all of those CCR containment facilities. If you look at what's happened in Tennessee, the Department of Environmental Quality in Tennessee adopted the federal CCR, but then went beyond that and said, we are going to also apply our rules to inactive compounds, and we're going to allow the Department of Environmental Quality in Tennessee, if they do not agree with the plans that TVA primarily submits to us, then we may require additional remediation. In Georgia, similar thing happened. They adopted the federal CCR, but then they went beyond that. And Georgia has just recently, they started off by requiring not only the CCR, but applying it to inactive sites, but they required Georgia Power to excavate 17 of 29 sites. Now they've actually added 2 more sites, and those 2 more sites are very large. Those 2 sites being excavated at Georgia Power are the same tonnage, basically around 29 million tons, as all of the sites of VEPCO is excavating. So they're very large sites. Florida has already adopted various policies on this, but Tampa Electric Company just decided to excavate a site which goes beyond the CCR, and the department down there approved it. In Alabama, I talked to the folks in Alabama, and they said they are going to adopt the federal CCR, but they're also going to have the leverage to adopt something beyond that. So when I looked at what all those other states were doing, I said, well, chances are North Carolina would have maybe done something. Plus, if you look at South Carolina, it's interesting. I saw a newspaper article about this, and it said that South Carolina was leading the Southeast because your preference shown by the settlements is to go with the excavation of all of these sites. So I thought, well, there's a really good chance that, and having served in the General Assembly, that the General Assembly in North Carolina wouldn't have just sat back, or the Department of Environmental Quality people in North Carolina wouldn't have just sat back and waited and not done anything when all these other states were doing something. That they would have probably moved forward and done something. And there's a final thing you have to realize. North Carolina has always sort of been out there and done stuff related to the environment, sometimes before other states, sometimes after, but it's not unusual. When I was in the General Assembly, we had a CAMA Act that went well beyond anything to do with the what other states had, but it was a Coastal Area Management Act, and it related to the beaches of North Carolina. While I was in the General Assembly, we adopted an act that was related to the mountains in North Carolina because someone had built a big, huge condo at the top of the mountain in Boone County, or in the ski district up there, Boone or whatever it was. And they said, wait, we don't want this type of development on the top of these mountains because it was, 10-story, big, huge condo. So we adopted something to protect the skylines, and I think it was called the Skyline Act. We also had the Clean Smokestack Act in North Carolina. So North Carolina has shown that it will move forward and adopt policies like the current CAMA. And so with that, I said, well, I don't think North Carolina would have done nothing when all the states around us were doing something, plus given the historical basis that I had with what North Carolina had done with the environment, I just would conclude that they would have adopted something. It may have been through the legislature or just through the environmental people, but they would have adopted something related to policy specific to North Carolina. And I think it would have been the federal CCR plus. It would not have just been, just the federal CCR.
Thank you, Dr. Wright. To follow up on your comments, do you believe Dan River had any impact on any legislation coming or policy, changes of opinion coming out of North Carolina?
As I stated in North Carolina, I'm sure it impacted the timing. If you're in the General Assembly and something like the accident at Dan River happens, you're going to move forward. But realize that in 2010, the EPA had already started studying this issue. The TVA accident happened in 2008, so there was already something going on at the federal level. When you start introducing a bill like CAMA, you had the accident at Dan River, you look and see what other states and what the federal government is doing. So I'm sure that the policymakers in North Carolina saw what was going on at the federal level, and they started looking at what policies they should adopt specific to the state of North Carolina. As to whether whether Dan River changed CAMA or not, it's hard for anybody to say. Like I said, I know it affected the timing, probably, but I'm not sure that you would have seen anything much different. And that's also buttressed by my having lived in North Carolina and served in the General Assembly. The people in the mountains of North Carolina and Asheville are very protective of the environment. The people on the coast are very protective. The people around these rivers, whether it's the Dan River, these other rivers, they're very protective. And I can see where the legislators in North Carolina would have had a lot of input into any of these coal ash ponds near some of these very scenic rivers and said, wait a minute, we need to do something specific to this. So I think Dan River certainly affected the timing. I'm not sure how much it affected what would have been different. And finally, I would just say, if you look at what's going on around the Southeast right now, everybody is moving towards excavation. There's a big move in all the surrounding states to excavate all of these ponds. So CAMA actually was less restrictive than that.
Thank you, Dr. Wright. Moving to you, Mr. Kieran. On page 9 of your pre-filed testimony, it discloses that fines or penalties incurred by Progress related to ash basin closure or management are excluded from rates. Are coal ash remediation costs related to violations of the Clean Water Act or other state or federal penalties included in rates?
Yeah, the remediation we're doing at the various sites is in accordance with the regulations, not tied to violations or guilty pleas, if that answers that.
I'm sorry, could you say that again?
Yeah, you said page 9?
Yes, of your pre-filed testimony.
Yeah, do you know what column number is that, or line number?
I do not have the line number.
Okay. If you can, I'm sorry, if you can ask me that again, I want to make sure I'm clear.
Are coal ash remediation costs related to violations of the Clean Water Act or other state or federal penalties included in rates?
If it was the Clean Water Act, if it was the plea agreement where there were violations, the 9 misdemeanors across the company, those would not be included in these costs.
Okay. What about outside of that plea agreement? Any violation outside of that plea agreement?
They were, as I explained earlier, violations that, or guilty pleas to violations, they were excluded from these costs.
On page 37 of your pre-filed direct testimony, you state that Progress historical handling of CCRs was reasonable, prudent, and consistent with industry standards over time. How does this square with the Dan River spill, particularly if witness O'Donnell's assertion of the company rejecting calls for video equipment to scope the pipe is true?
Yeah, I look at the overall time frame of how long we operated these facilities from the 20s through today. So that's the Dan River event, in my mind, was one fraction of time that we overall managed these facilities. That was also discussed in the North Carolina case, where it talked about the order talked about that the Dan River, again, those issues were a fraction of time over the overall almost 100 years of operating these facilities. So I feel we were in operation, we were maintaining those basins in accordance with industry standards and compliance with the requirements when you look at the overall timeline.
So is your testimony that even if Dan River could have been completed, or strike that, even if Dan River could have been prevented, Progress Energies, Duke Progress Energy, or Duke Energy Progress, their historical handling of CCRs was still reasonable, prudent, and consistent with industry standards?
Yes, I confirm that.
Thank you.
Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Karen, I guess for you first, just one question here. Commissioner Williams just asked you if the company proposed to collect from customers any non-compliance penalties, and I think you just answered that, but to add on to his question a little bit, does that also apply to any associated attorney's fees due to the handling of CCRs?
Yeah, and if it was a violation or a guilty plea, those fees would be excluded from the case.
Okay, thank you. Dr. Wright, couple for you. On pages 12 and 13 of your direct testimony, give you a second to get there. I think yes, the bottom of 12, yes, top of 13. You discuss the sharing of Duke Energy Progress's environmental expenses, and if you could describe maybe in general how this allocation is made. I know you go on to talk about taxes being a little different on certain assets and certain things, but if you could describe this sharing or allocation, if you will.
Well, generally speaking, when you're looking at the allocation of cost, the first question you ask is who benefits from these costs? And obviously, if it's dealing with electric power that is generated, whether it's generated in North or South Carolina, it's supplied to all the customers in the system. So those costs, as they pertain to particularly transmission and generation, are generally allocated, and usually I believe they're allocated based on the energy sales. So environmental costs often, especially something like reagents, are dependent upon how many kilowatt hours are sold. So that sort of designates how many tons of coal you might burn or other fuels like that. So that's how that is allocated usually. I would assume the other costs like taxes and workers, employees, all those benefits, I assume those are generally allocated on energy too, but an accounting witness may tell you if they allocate differently.
Yes, I was also referring to those other costs other than environmental. I mean, for instance, you talk about the rail.
Yeah, the fuel and stuff like that.
Being cheaper, with North Carolina being closer to the mines. Similarly, you talk about DE Progress receiving a revenue stream from reuse of coal ash byproducts, and I think it's come out earlier in this case. That number was certainly much higher than I had thought before. I think it was closer to 90%, high 80s, 87%. Similarly, with that much being for reuse, similarly, are those revenue streams can you discuss how they're allocated back among the ratepayers of South Carolina and North Carolina?
I'm not exactly sure how they would be allocated. I'm not sure if Mr. Karen knows, because the accountants would do that, but it may be based on energy too. I'm just not sure. Do you know, Joe?
Mr. Karen?
I'm not sure how the accounting takes place on that.
Is there another witness maybe that can address that we have left on the sheet?
Bateman. I think witness Bateman can handle that.
Okay. I think she was, well, maybe not now, but anyway.
If it helps, I guess I could see if we can volunteer a late filed exhibit or something.
That would be good.
Would that suffice?
Do that, Mr. Chairman.
Okay, we'll do that as a late file exhibit, number 41.
Okay.
Thank you. And Dr. Wright, I had one more question for you, but in talking with Chairman Randall, I think he's going to ask it of you, so I'm done. Thank you, Mr. Chairman.
Thank you, Commissioner Whitfield. Commissioner Howard.
Dr. Wright, Fern, good morning.
Good morning.
Dr. Wright, ORS witness Zachary Payne recommended the deferral balance as being divided into capital-related costs and operating-related costs. With that in mind, are you recommending the deferred operating costs be charged to capital charging costs, weighted cost of capital?
Well, there's a cost of capital associated with the dollars that were spent, and whether you charge them off as a capital or operating cost, you had to borrow the money to pay those costs and then defer recovery of those costs. Now, generally speaking, what happens in a business and in regulation, if you have an operating expense, you recover that on an ongoing basis. Because we haven't recovered it on an ongoing basis, there is a cost of capital. I mean, you're deferring the recovery. You had to provide the cash. The company had to get the cash somewhere, and there's a cost for money. So obviously that's got to be recovered. Otherwise, the company will be under-recovered.
Okay, I'm not saying that I guess I don't understand why the operating costs would carried out? Why this wasn't part of a? I guess I'm questioning your answer to witnesses Payne's dividing them into two parts.
Well, let me see if I can explain it this way. With the operating cost and a capital cost, generally speaking, a company will recover their operating cost contemporaneously.
Correct.
And actually, there will be some sort of carrying charge often associated with that based on how much capital the company needs to operate over a certain period of time. In this particular case, by trying to designate this as an operating cost, and then 3 years down the road, you've put it in a deferred account, and now you're going to try to recover it, but you don't get to recover a return, well, it costs money to borrow that capital. So if you don't get the money that it costs, then you're actually not allowed a chance to recover what your true costs were. And that's a violation of the regulatory compact. I mean, to me, it's pretty clear. If you're not allowed to recover a return, then you're certainly not allowed to an opportunity to recover your cost.
I'm with you now. Thank you. Hearn.
Yes, sir.
Do a timeline, if you don't mind, just for my education. And I'll let you pick the starting date, but how many ash pond breaches have there been in some period of time? And you pick that period of time.
Yeah, if I go back to maybe year 2000 forward.
That's fine. After the year I came on a commission, so I wouldn't be responsible for anything before that.
I'm looking at
term.
industry-wide events, some of the significant industry-wide events. Of course, there was TVA in December, I think it was 22nd of 2008. Also in about the 2005-2006 timeframe, there was a significant release on the Delaware River between Pennsylvania and New Jersey, where a retainer gates failed and released a significant amount of ash and water. Probably, it's been identified as the second largest release of ash into a river, happened in Delaware. And there was a Wisconsin event also where they had a failure of an embankment. And those are probably over about the last 15 or so years.
Well, you answered my next question. My next question is what caused these particular breaches leading up to the Dan River breach. Are there any inspections in place, or how do you inspect to see that a dam has a potential breach coming up, and how do you prevent it?
Yeah, the way we look at that is we have trained engineers, professional engineers assigned to each of the basins. So per the CCR rule as well as CAMA, on a weekly basis, those engineers do a detailed inspection of that basin. They look at the complete walk down of that basin. They look at the activities of that basin. So that gives us a weekly check from a professional engineer that looks at that basin. We also do a very detailed annual with a third party that comes in and does an independent inspection of those facilities. As part of the CCR role and as part of what we did is with AppSat in 2014, we did a very detailed engineering analysis of every one of our basins. It was basically a reverse engineering reconfiguration. We did core borings. We determined how that basin was originally built, and we looked at any of the factors of safety that could be impacted to that basin. For instance, if it's applicable to a seismic event, if the underlying soils of that basin were acceptable to liquefaction. And we see that a lot of times along riverways. That sandy soil along the river, you build a dam adjacent to those sandy soils, they can be susceptible to what we call liquefaction. Within an earthquake type event, it starts to shake and those soils can liquefy. So we did very detailed analysis through core borings across our dams if we had any susceptibility to liquefaction at those dams. So we did this very detailed engineering analysis, which has to be done every 5 years per the CCR rule. We have the annual independent engineers analysis. We had the state regulators come out at least annually to do their inspection of the dams, and then we do our weekly inspection with our civil engineers.
Let's talk about Dan River. There's some confusion in mind as whether the management of Duke knew that the pipe was there. Did y'all know the pipe was there?
Yeah, that pipe there was two actual pipes in that basin. There was a corrugated metal pipe, and then there was a concrete reinforced pipe, both service or stormwater drains. So we knew those pipes were there, and the early inspections, the recommendations were to inspect the outfall of those pipes for any turbidity. Was the water clear? If you start to see any soil or anything being carried in that water, that would be an indication that you had a leak in that pipe from the ash basin. So we were doing those inspections from a turbidity standpoint.
Well, Commissioner Williams mentioned the cameras, and apparently according to the witness that the Duke engineers requested the money to do the video cameras or to buy the cameras, and it was denied by management. Could you comment on that?
I know in the plea agreement and the statement of facts, there was a request, it's before my time, and from one of the engineers to do a video inspection of that pipe to see if there was any degradation going on in that pipe. So I am familiar that there were emails and that was denied.
Well, do you feel like the admitted requirement was sufficient in determining whether there was a leak in the pipe?
Typically, that's a standard practice, both with whether it's a pipe or a seep. What you look for is there any material, is it clear water, or are there any particles being transferred through that water? And we do that when we have a seep. We look at that. When we look at that, all of our pipes, we look at that to see it's a common practice if you're having any material that's being passed along with that water.
Hindsight is wonderful, but hindsight, would you have ordered the cameras?
You know, I can't put myself in the place of the management team at that time.
Yeah, go ahead. Take a chance.
Knowing what I know today, and it probably would have been yes, but that's knowing what I know today.
Well, that's hindsight. Thank you very much. Thank you both very much. Enjoyed your testimony. Thank you, Mr. Chairman.
Thank you. Commissioners. Commissioner Urban.
Mr. Karen, is Duke or Duke Energy Progress currently or anticipating in the future to be in litigation for any other Clean Water Act violations related to CCR cost?
And not that I'm aware of.
Is there anyone else in the company who would know definitively?
My understanding is we don't have any pending violations for Clean Water.
All right. Did you also, or do you test the groundwater to see if there's contamination underneath the coal ash?
Yeah, there's two. It's groundwater monitoring that we do. The CCR role has requirements for groundwater monitoring, and so does CAMA. And that information is needed as we prepare our closure plans and determine our corrective action plan with groundwater. Slight difference in those is the CCR role has you test for groundwater at the waste boundary or at the dam of the basin, where the CAMA CCR or CAMA roles in the state, very similar to South Carolina, requires to test typically at the compliance boundary or around areas of the site, just to ensure that we don't have secondary sources, that it's not background, and we understand exactly any impacts from the basin itself.
So have those tests that you described, are they ongoing, or have they been completed, or?
The initial tests have been completed, and with regards to the CCR role, those are posted on our what we call our operating record, as well as our external public website. Those results were posted in January of this year. So all the results for all those basins, all the detailed analysis and the detailed, if there's any exceedance, are on that website today.
Just to try to capture big picture from that data, how many sites have contaminated the groundwater?
With regards to the CCR role, my understanding is the only site, I don't have all the details in front of me because they test for a lot of constituents, is the Mayo site did not have any exceedances from our January submittal. But our other sites did have exceedances, various different constituents from our January submittal.
Would you be in compliance of CAMA if you put a line, aligning and move the coal ash into a line basin on the same property?
If we were to construct a new lined facility as an ash basin, but we're going through the process of stopping all flows, that the operating plants, we will go into dry ash handling. That'll be landfilled into a permitted landfill, but we would not open up a new ash basin. In fact, I think our last ash basin that we opened was in 1985.
So I misspoke. I was thinking of landfill rather than transporting it out. Is that an option that you can consider under the regulations?
Well, we have landfills, and we've been operating landfills.
Yes, sir. I'm talking about lined landfills.
All of our landfills are lined. Any
lined.
new constructed landfill will be lined and permitted per the state.
All right, sir. Thank you, sir. Dr. Wright, how did the North Carolina Commission come up with the $30 million fine? Do you know how they arrived at that?
I don't know how they arrived at it. I do know it was a fine related to the allowed return. It was about 13% of the allowed return over a 5-year period. So they did not find any of the costs were imprudent or unreasonable, but they said because of the company's admitted guilt in the Dan River incident that they should, levy a fine. How they came up with the 13% of the allowed return, I don't know.
Thank you, sir. Those are all the questions I have.
Thank you. Just a couple here. Dr. Wright, we've talked Dan River a little bit and talked about the fraction of time that the leak happened and, talking video rejection. With your regulator hat on, if you were persuaded that negligence on the part of Duke Energy led to the Dan River plant leak, would you support the recovery of any of the incremental costs due to CAMA from any ratepayers in the state of South Carolina or North Carolina?
Well, let me go back and think about what the North Carolina Commission did. And had I been on the commission at the time, asked myself the question, would I have done that? I think the company has already accepted responsibility, and they did pay a fine. They were penalized for that, and they accepted all the cleanup costs. They aren't charging any ratepayers that, and they accepted all the other costs associated with the Dan River spill. But the North Carolina Commission, and it's on page 204 of the recent DEP order, they said, further, the mismanagement to which DEP pled guilty was only for a fraction of the time DEP operated the impoundments. No evidence was submitted that DEP's management was imprudent from the initial date of operation. When I read about the accident at Dan River, I read all the accident reports. I worked 12 years in the chemical industry, and I worked at Occidental Chemical Company and Corning Glass. You have accidents happen. The company accepted their responsibility for their accident, and they were penalized by the federal government. I think to be penalized again by the North Carolina Commission was a double penalty. Now let's back off from there and say, okay, CAMA. No one in this case has said that CAMA is an unreasonable law or unreasonable policy. So I asked myself the question, if you were in North Carolina as a legislator or as a commissioner on the Utility Commission, what would North Carolina be doing today? And as I look around the Southeast, in Virginia, they're excavating all their sites. In Tennessee, they're probably going to be excavating all their sites because there are lawsuits filed right now. In Georgia, 17 of the 29 initial sites were being excavated. Now an additional 2 are being excavated, and those 2 are real large. Florida has excavated actually they do beneficiation for most of theirs, but Tampa Electric just said they're going to excavate one of theirs that they don't have to excavate. They could cap in place. And in South Carolina, you have shown a preference. It's not an adopted policy, but every coal ash facility in the state of South Carolina is being excavated. So I asked myself the question, would North Carolina have just sat there and done nothing, or would they have said, okay, we've got to at least do what the CCR requires, which is some potential cap in place and some excavation? And why is it right for all these other states to have the excavation at all of their sites, including South Carolina, and yet North Carolina not be allowed the same type of option for their citizens of their state? So I just have to think that you have to look around and ask yourself, well, is North Carolina really different? South Carolina started the excavation in 2012. In 2013 with SC DN and Santee Cooper, long before the CCR was passed, which was 2015. CAMA was adopted in 2014. In fact, the South Carolina in SC DN and Santee Cooper excavations were before Dan River.
Understand all that, and that's a little past my negligence question. So let me ask you this, since we're talking CAMA and sharing CAMA related costs, because other people have been asked this, and on page 23 of your pre-filed direct testimony, you state that the costs related to CAMA are in excess of CCR-related costs, and they are discussed by witness Karen. And on page 30 of witness Karen's pre-filed direct testimony, he suggests that the issue is addressed in greater detail in your testimony. So that was a pretty good whip at that. But so let me just ask you this question that other people have been asking, and just see what you say about it. And you can give this as a short explanation of why Duke Energy Progress feels that the CAMA cost for compliance in North Carolina should be borne by or should be shared by the South Carolina customers.
Okay, let me answer part of the first thing you said about us saying, that he did it. I can discuss CAMA and the cost at a very high level, but in fact, what I was referring to here on page 23, line 7, are there any costs related to CAMA that are in excess of the federal CCR rules? Mr. Karen can go plant by plant and tell you if there are costs. And in my discussions with Mr. Karen, and he can follow up after I finish, he said there's not a whole lot of difference when you start doing the actual analysis, the engineering analysis as to, okay, how would we close this under CCR? He said there's not a whole lot of difference. So I'll let him go through the plants and talk about that. That's what I was referring to there.
Gotcha.
Now, as far as the allocation of the cost and CAMA, the first thing you have to do is ask who benefits. And I don't think there's any question that the citizens of the state of South Carolina have benefited from the power produced by these coal ash facilities. And in fact, they started in 1920. So almost 100 years, almost a century. And those costs, as I show in my testimony, my direct testimony, have been a large part of why the state of South Carolina has had electric rates below the national average for many, many years. And you've got low-cost, reliable power, and it's helped benefit every citizen in South Carolina with jobs, with all sorts of benefits. Now, when you ask yourself that, okay, who benefits the customers in both states? But at the same time, as part of your obligation, when you get to receive the benefits of this power, all the citizens of North and South Carolina who receive the low-cost power, all these customers, they also have to pay for the life cycle cost of a facility. And part of that life cycle is the disposal of any byproduct or any of these waste, and the disposal based on the current standards. And unfortunately, those standards have changed. Absent that, then we wouldn't be here. But that's what we're faced with today. So the company does not have a choice. They can't pick and choose which laws they want to look at. And I think the third thing you have to ask yourself, not only is CAMA reasonable, nobody said it's not, who benefits? All the ratepayers. Who should pay? Anyone who, and what should you pay? All of the life cycle costs. And then finally, you have to ask, what happens if you don't share in these costs? And I think there are a lot of unintended consequences if you don't share in these costs. And I've discussed this in both my direct and rebuttal testimony. I think one of the unintended consequences is your cost of capital is going to go up. Second consequence is North Carolina may ask, well, doggone, if we're having to pay all these costs, maybe we don't, this sharing of these facilities isn't a good idea anymore. So it's just a lot of unintended consequences if we go down this road, and I just don't think it's the right thing to do, because like I said, the people who benefited were the citizens of both states. And unfortunately, the people who have to pay for the life cycle cost are also the citizens of both states.
Thank you. Just one more question for Mr. Karen. And I'm on just, we've talked Witness O'Donnell's Table 9. It's on page 42, calculates ratio of coal ash asset retirement obligations versus KWH's of coal generation. And Progress's ratios, and I think we've talked about this before, but Progress's ratios look much higher than other electric utilities. Tell us the reason for that.
Yeah, and that's in regards to our overall ARO at Progress. And what I stated in my rebuttal, I have about 22 reasons or factors that you have to take into consideration when you're looking at ARO costs at a specific site. Just by doing cost per megawatt, you've got to look at the number of plants in that company's fleet. You've got to look at the age of the plants and how long those basins were operating. You've got to look at, did any of those sites utilize dry ash handling early on, or when did they start dry ash handling? The type of CCR basins in that fleet. So those 22 factors, you really need to take those into consideration before you can determine you're doing an apples-to-apples comparison. And I will state that the majority of those factors I state in my rebuttal testimony are publicly available information. You can go to the CCR or the EPA CCR buy station website, or each utility, as I mentioned earlier, in our public website. Each utility has to list all those details from a public website standpoint. History of construction, number of basins, amount of ash, acreage in those basins, how many landfills, acreage in landfills. So you can go through. When you look at those different stations, they're very unique. The different companies will have. So if you do that type of analysis and look at those 22 factors I talked about, I think it'll be very clear. You just can't line them up and say, there's a lot more costs at Progress, so they must be mismanaging, or their costs are much higher than the others. I think you've got to look at all those 22 factors, and then you can draw a conclusion on the individual cost and any differences.
May I add something real quick?
Sure.
Because I think the other thing you have to do is, he took costs that are probably a year or two old. For example, he said in Virginia they were going to spend $624 million. The most recent number for Virginia is 5.6 to over $8 billion because of the new law they passed. So that's some 10 to 12 times what he's estimated. In Georgia Power, he estimated the cost at $1.42 billion. Right now, they're at $2 billion, which is a little bit higher, but that doesn't include the last two sites that are as large as all of Virginia's. So you add another $5 billion on top of that. Instead of being $1.4 billion, you're at $5, $7 billion, $8 billion. I mean, the costs are really, really different. For Alabama Power, he said $324 million. Alabama Power says right now, and this is only if they can cap in place some sites, it's $1.14 billion, some 3 times higher. So you've got to get the newest numbers, and that's the problem. North Carolina was ahead. South Carolina was ahead of everybody, so the numbers just aren't apples to apples for that reason, too.
Thank you. Okay. Any redirect?
No, sir.
Okay, thank you. Okay, gentlemen, thank you for your testimony.
Briefly, Mr. Chairman, I omitted to introduce DHEC Order 15-23-HW. Witness vouch for it. I'd like to move it in as the next hearing exhibit.
We'll enter that as exhibit number 42.
Thank you, sir.
Okay, anything else? Gentlemen, thank you for your testimony. You may step down and be excused. Okay. We are at the 12:37 time frame, so we're going to break for lunch. We'll be back at 1:46.